CO2 2511 MF 180. On the Zoom, who do we have?
Kurt Laker, Your Honor, for the plaintiff, Rocket Mortgage.
And then present in court, I'm sorry, sir. She told me you were hard of hearing. I need to speak up. Can you hear me okay, sir?
Yes.
Okay. Let me know, is that thing working better?
Yeah.
Okay, thank you. So this is Rocket Mortgage versus Joseph A. Novak, Maria G. Novak, in the state of Indiana through its Department of Revenue. We're here for a mortgage foreclosure. There's been some things filed and we set this for hearing to try to sort things out. And sir, you filed some things contesting jurisdiction and service. Is that correct?
Yes.
Okay. What would you like to argue to the court?
Capacity. I don't know. Trial Rule 17A, the plaintiff must identify the real parties and interests.
And you feel they have not, done that?
Yes.
Okay. What else would you like to argue to the court?
Jurisdiction, which I guess is part of capacity, I guess.
Okay. And you're saying the court does not have jurisdiction? And why are you saying that?
Well, I'm asking what capacity. I don't know. I mean, like an officer, police officer in their capacity as officer, then they can be in their capacity as their private capacity.
Your paperwork. Because I think you filed a motion to stay these proceedings pending a clarification of jurisdiction. It was one of the papers that you filed.
Yes.
And so we set this for hearing so we can get some clarification of what you're asking this court to do. And that's what I'm trying to figure out. I want to know what the plaintiff is asking and then what you are asking. Then I can see what kind of a relief I can grant or not grant. So you wanted to stay these proceedings pending clarification of jurisdiction. Is that correct?
Yes.
Okay. And why do you think the court does not have jurisdiction?
Well, I want capacity defined. What capacity am I being compelled here in?
All right. Anything else that you want to argue to the court?
Nothing I can think of right now. I'm drawing a blank. I'm good at writing this stuff up. I just.
It's tough when you're under pressure here. Yeah, I understand. So what I'm going to do is I'm going to hear from the plaintiff and then I'm going to come back and hear from you in response to them. Okay. From the plaintiff standpoint, Mr. Novak is contesting jurisdiction, saying that we don't have jurisdiction over him or this case. Any response from the plaintiff?
Yes, Your Honor. As the court knows, jurisdiction is acquired by service of summons. The plaintiff did deliver, or caused to be delivered, a summons to Mr. Novak by sheriff's service. A copy of the summons and complaint was dropped off at his residence, same residence that he used that as a return address when he filed his responsive pleadings with the court. So I don't think there's any dispute that that's where Mr. Novak lives. The complaint and summons.
All right, folks, buckle up, because today's video is a 2-for-1 special asterisk in Sovereign Citizen Fantasy Court. We've got not one, but 2 defendants, in 2 different states, both absolutely convinced they've cracked some kind of legal cheat code that judges, lawyers, and the entire justice system somehow missed. And spoiler alert, they haven't. What we're about to watch is a masterclass in confidently saying WDs that sound legal, while completely missing how the law actually works. In this first case, we're dealing with a mortgage foreclosure brought by Rocket Mortgage. Straightforward case, right? Wrong, because our defendant decides this is the perfect time to challenge jurisdiction and even whether he qualifies as a real person. Yes, we're going that asterisk deep into Sovereign Citizen, how the court responds, because this is where reality slowly but firmly collides with internet law theories. Watch how procedure, not passion, wins the day. And ask yourself as we go, if these arguments actually
were dropped off by the sheriff and subsequently mailed, both of those facts are reflected on the court's docket. That is the means under Trial Rule 4.1A3 by which we establish service and effectively bring Mr. Novak into court. We believe we've done that. And at this point, all we're asking the court to do is review the service, conclude that personal jurisdiction exists over Mr. Novak, and order him to file an answer, responsive pleading, or take whatever action he decides to take in response to the complaint.
Mr. Novak, I'm looking at the file and I'm seeing a summons that was mailed and left at 7334 North 200 East in LaPorte, Indiana, which is the property that's subject to this petition for foreclosure. And under the trial
definitions of things, and like for instance, traffic, Trial 9. I mean, you look up, there's definitions of words, and you go to another title, and there's a bunch of other definitions. The definition keeps changing. My view of the word residence, it's Latin. Res is the object of a trust. Ident is the same as identical, identify. Resident, to me, I think that means you're saying you're the object of a trust. And I know all these words have legal terminology. I don't know what they, maybe my.
This is where we immediately see the problem, not legally, but strategically. Mr. Novak is throwing out words like capacity, real party in interest, and jurisdiction, but notice what's missing: a clear, coherent. Courts don't rule on vibes. They rule on specific claims tied to specific laws. When the judge asks, "What would you like to argue?" that's not a trap, that's an open invitation to make your case. And instead, we get uncertainty, hesitation, and a lot of, "I don't know." This is extremely common with sovereign citizen filings. They look polished on paper because they're often copied from templates online, but the moment someone has to explain them out loud, everything collapses. Jurisdiction isn't a magic word. You don't lose jurisdiction just because someone questions it. You have to show why the court lacks authority, and so far, that hasn't happened.
How do you identify me as a resident? What makes me a resident?
Okay.
And the service says, the sheriff's service, which I don't have it with me, but it said just left at last address. It doesn't say where it was left, who it was left with, when it was left, how it was left. And at the top it says the officer's instructions, it's circled read. And there's one that says left, and left isn't circled. I don't know what that means. Was he supposed to show up and read it to me?
Any response, counsel?
Your Honor, I mean, just in regards to the leaving of the summons, I mean, the docket is clear, what occurred. The summons was left along with the complaint. It was mailed. I don't think there's any dispute that Mr. Novak actually received it. Receipt of the summons and complaint is what caused him to file these pleadings. So it's those are the hurdles. Those are the jurisdictional hurdles that we're required to hit, and we've hit them. He's here now. He's filed an appearance. He's aware that we filed a claim against him. I think the court pretty clearly has personal jurisdiction regarding some of the other sort of esoteric arguments that Mr. Novak is making about the meaning of various words. I guess I would just point out that the Trial Rule 4 speaks of leaving it as his place of abode. residency, domicile, these other esoteric concepts are just not baked into the trial rules for purposes of service of summons. Mr. Novak is a real person. He's sitting in front of us. He lives in a place. We delivered the summons to that place, and the sheriff mailed a copy of it to that same place. So I'm not sure what else is to be expected of my client to properly put him on notice of the claims that have been made against him. He has everything he needs to put forth whatever defense that he chooses to make, and we would ask that the court order him to do that at this point.
Right. Mr. Novak, I understand what you're saying about resident, and I understand what you're saying about capacity. Any other arguments you want to make to the court?
He said real person. Is that natural person? Because when I looked up the definition of person in
Right here is where fantasy meets procedure, and procedure wins every time. The plaintiff's attorney isn't emotional, he's not dramatic, and he's not improvising. He's calmly walking through service of process, which is how courts actually acquire jurisdiction over people. Sheriff served the summons. It was left at the residence. It was mailed. All of that is documented on the docket. That's it. That's the ballgame. Notice how the argument isn't, did you agree to be served, or did you consent? None of that matters. The question is, did the plaintiff follow the rules, and according to the record, they absolutely did. The fact that Mr. Novak filed paperwork in response is the ultimate proof he received notice. Courts care about notice and opportunity to respond, not philosophical objections.
Okay.
and I claim the patented land. I literally have the land patent signed by Martin Van Buren in 1837, and it's certified from the Bureau of Land Management Government Land Office, the Department of the Interior. It's patented land. It's not property. And if I own land, do I need to pay for rights in it?
Okay. And you understand that the mortgage company that's the plaintiff is claiming an interest in that land because of a mortgage document.
Yes, and I really don't want to get into.
I want to,
From what I understand, if I get into merits, then that puts me in general insurance. I'm not even an amateur litigant. I'm just Joe Blow down the street. That's all.
I understand.
And I'm being careful. I'm not trying to resist anything. And
I understand you're hearing here in a limited purpose only. So let me do this. I think I understand your arguments. I'm going to go back and I'm going to reread what you have filed and all your pleadings. And counsel, I'll read what you have filed in your pleadings, and then I'll issue a ruling as to what the clarification Mr. Novak is requesting. That ruling may be one, that there has been no proof of service, or it may be two, there has been proof of service, and now Mr. Novak, you have X amount of time to respond, and then you can file any other defenses and responses that you have at that time. Okay.
And I have recordings with the county recorder about the land and about me personally.
And you'll be able to file all of that with the court to prove what your interest is. I've been doing this a long time. I've only seen a couple of actual patents, land patents come through. But I'm happy to entertain whatever that proof that you have. But let me dig into the actual capacity.
And just like that, the jurisdiction argument is dead. The judge confirms the address, confirms service, and ties it directly to the property being foreclosed on ***. That's not accidental, that's surgical. Courts don't entertain abstract debates when the facts are this clean. If you live there, or serve there, and the CA, what's important here is the judge's tone. She's not mocking him. She's not rushing him. She's explaining, clearly, that the legal requirements have been met. This is what due process actually looks like. And yet, instead of pivoting to a defense on the merits, Mr. Novak doubles down and wanders even further into sovereign citizen mythology. That decision is about
But are you the defendant, Paul Robert Strumpler?
As I said, I am here on behalf of the defendant under special limited appearance.
Can you make sure the microphone is tipped towards your mouth there? Thank you.
I'm here under special limited appearance on behalf of the named defendant.
Okay, I don't know what that means. I just need to know whether you are Paul Robert Strumpler.
You can refer to me as Paul, yes.
Okay. I'm going to take it that you are Paul Robert Strumpler, the defendant in this case. I'm going to call the case now. We're on the record in 25T422, People versus Paul Robert Strumpler. Mr. Strumpler is present in court in person, pro se today. Mr. Garrett is here for the district attorney's office. We're scheduled today for appearance of counsel. Mr. Strumpler, last time you were in court, I believe you said that you were considering getting an attorney. Have you obtained an attorney?
I was wondering if you had a chance to look over any of the exhibits that were filed recently into the case.
I see that you filed a number of things yesterday,
Mhm.
and I have not looked at them, but based upon their titles, they are meaningless in this case.
Well, the reason I brought that up is because some of those documents pertain to the attorney issue.
Okay, which one?
You could go to the one titled General POA, and I can give you the exhibit number here in a moment.
Okay.
That would be exhibit 5.
All right, I'm looking at what is labeled Exhibit 5. Okay, I don't understand what this is. Well, how does this have to do with you getting an attorney?
The attorney issue, so that we can, further have this conversation. If that's going to take some more time, that's fine. I was under the impression that I was here today just to explain whether I would be here pro se or not. I prefer to be here sui juris pro per, and if you prefer pro se, we can go with that. For the record, I prefer sui juris pro per, and it would be nice to know if you have gone through these documents in full, so that the information is in both our minds.
So let me explain something to you. You can file documents with the court, but they don't mean anything unless you're asking me to do something. If you're asking me to do something, you would file a motion to whatever. I don't know what you might want to
Sure.
ask me to do.
Sure.
Just filing, for example, all these documents, ecclesiastical deed poll, all these exhibits, notice, last will, none of this is it's all meaningless. It has no meaning in this case or effect. Mr. Garrett?
And Your Honor, because I saw the exhibits that were submitted to our office, and then as well as kind of what we've seen today. I know it's kind of rare for the prosecution to express concerns in competency, but at this time, I think I would be asking. I do have concerns for competency, and I would be asking the court to order an out of custody comp eval.
Okay. I think I'm going to want you to do that in writing.
Okay.
I want to have that documented. Okay. So, Mr. Strumpler, at this point in your case, all we're talking about is whether you want to have an attorney or not, and whether you want to plead guilty or not guilty, and set it for trial. So that's what we're trying to decide right now.
I'm aware. I would like to know who's bringing the claims and to see the claim before I can plead to any charges.
This is where things go completely off the rails. Mr. Novak is now trying to dismantle the word resident using Latin fragments, trust law buzzwords, and dictionary hopping. This is a classic sovereign citizen move. If you can't beat the law, try to redefine the language. The problem is, courts don't use internet etymology. They use statutory definitions, and common legal meaning. Residency isn't metaphysical. It doesn't require consent. It doesn't turn you into a trust asset. It simply means you live there.